colleagues and listeners. First of all, I would like to share some information about Uzbekistan, which is often called the Pearl of the East and is known for its unique cultural heritage. The country is home to numerous ancient architectural wonders, including the famous blue tiles of the Registan in Samarkand and the stunning monuments of Bukhara. Uzbekistan is a vibrant and fascinating country with a rich history that continues to attract tourists and investors from around the world. Welcome to Uzbekistan. Introduction to Cyber Law, from general law to the digital era. Introduction. Dear listeners, today we explore the evolution from general law to cyber law, tracing this transformation over a 90-minute lecture in the context of our digital society. We'll start with an overview of general law, based on judicial decisions and precedents, which has shaped legal systems in many countries. We'll examine how its principles have traditionally governed legal relationships and dispute resolution. The technological revolution created new legal challenges that general law struggled to address. The internet, digital communications, and e-commerce raised unprecedented questions about jurisdiction, identity, and virtual property. This gap led to the emergence of cyber law, a field tailored to regulate digital interactions. We'll cover key cyber law topics including data protection and online privacy, e-commerce and digital contracts, intellectual property in the digital age, cybersecurity and cybercrime, online freedom of expression, AI and the law, blockchain and smart contracts. We'll draw parallels between general law principles and their cyber law counterparts, highlighting continuities and changes necessitated by the digital revolution. Our aim is to provide knowledge about current cyber law and encourage critical thinking about future challenges. Let's begin our journey from general law to cyber law, exploring the legal profession's adaptation to the 21st century digital landscape. Fundamentals of cyber law. Welcome, dear listeners, to our exploration of the fundamentals of cyber law. In this section, we'll delve into the core concepts, principles, and structures that form the foundation of this rapidly evolving field. Let's begin our journey through the digital legal landscape. Genesis, concept, and subject matter of cyber law. Cyber law emerged in the 1990s to address legal challenges posed by the digital revolution. It encompasses issues related to e-commerce, data protection, cybercrime, and digital intellectual property. Key events shaping its development include the commercialization of the Internet and the U.S. Telecommunications Act of 1996. The field continues to evolve, reflecting the dynamic nature of the digital environment. Cyber law applies traditional legal principles to new digital contexts, adapting to technological advancements and emerging online behaviors. Its scope is vast, intersecting with various legal practices in the digital realm. Fundamental principles of cyber law and their role in regulating digital relations. Cyber law is guided by several fundamental principles. Technological neutrality ensures laws remain applicable across different technologies. Network neutrality prevents discrimination in internet traffic management. The principle of intermediary liability protection shields platforms from user-generated content liability under certain conditions. Data minimization and consent are crucial in data protection, ensuring only necessary data is collected with user agreement. These principles collectively aim to balance the interests of various stakeholders in the digital ecosystem, promoting innovation while protecting individual rights and maintaining the integrity of digital interactions. Sources of cyber law, international acts, national legislation, ethics, and precedents. Cyber law draws from diverse sources, reflecting the complex nature of the digital environment. International treaties like the Budapest Convention on Cybercrime provide frameworks for addressing cross-border issues. National legislation, such as the U.S. Computer Fraud and Abuse Act and the EU's GDPR, set standards for cybercrime prevention and data protection. Case law has been instrumental in shaping cyber law, with landmark cases establishing important precedents. Soft law instruments, including guidelines from organizations like the OECD, contribute to the development of cyber law norms. Industry self-regulation, such as ICANN's policies, also plays a crucial role in governing the digital landscape. Subjects of cyber law relations, peculiarities of legal status and classification. Cyber law encompasses a diverse range of subjects, each with distinct legal statuses. These include individuals, legal entities, internet service providers, ISPs, governmental bodies, NGOs, and emerging AI systems. Each subject has unique rights, obligations, and responsibilities under cyber law. Individuals have seen their rights enhanced, particularly in terms of data protection and privacy. Legal entities face numerous obligations in the digital sphere. ISPs and online platforms balance the role of neutral conduit with active participant in content moderation. Governmental bodies shape and enforce cyber law while grappling with digital surveillance and national security challenges. Objects of cyber law: relations, digital assets, information, technologies, and their specifics. Cyber law deals with unique objects characterized by their intangible nature. These include digital assets, information, and technologies. Digital assets, such as cryptocurrencies and NFTs, present novel questions of ownership and valuation. Information, particularly personal data, is a crucial object in cyber law, with regulations emphasizing its protection. Technologies themselves can be objects of cyber law, with issues surrounding their development, use, and regulation. The intangible and dynamic nature of these objects complicates their identification and classification within existing legal frameworks, necessitating new approaches to their regulation and protection in the digital age. Methods of legal regulation in cyberspace: imperative, dispositive, and recommendatory. Cyber law employs various regulatory methods to address digital challenges. The imperative method involves mandatory rules, often backed by legal sanctions, as seen in the EU's GDPR. The dispositive method emphasizes contractual freedom, particularly relevant in e-commerce and domain name disputes. The recommendatory method uses soft law instruments and best practices. Organizations like the IETF develop technical standards that shape Internet architecture. These methods collectively aim to create a balanced regulatory approach that can adapt to the rapidly evolving digital landscape while maintaining legal certainty and protecting individual rights. Legal methods and means of protection and self-defense of rights and interests of subjects in cyberspace. Protecting rights in cyberspace involves innovative legal methods. Technical protection measures, such as encryption, are often backed by legal provisions like the DMCA's Digital Millennium Copyright Act, anti-circumvention rules. Self-help remedies, including notice and takedown procedures, have gained prominence. ICANN's UDRP provides an efficient means for resolving domain name disputes. Legal frameworks are adapting to provide better protection, with many jurisdictions now recognizing data breach notification requirements. Alternative dispute resolution mechanisms, like online arbitration, offer efficient ways to resolve digital conflicts. These methods aim to provide effective protection while addressing the unique challenges of the digital environment. Conflicts in cyber law: causes of emergence and peculiarities of conflict regulation. Conflicts in cyber law often arise due to the Internet's borderless nature and the clash between traditional legal concepts and digital realities. Jurisdictional issues are common, as illustrated by cases like Yahoo! Inc. v. LICRA. The tension between privacy rights and security interests, exemplified by encryption debates, is another area of conflict. Intellectual property rights in the digital age generate significant conflicts, challenging traditional paradigms. The regulation of emerging technologies creates new areas of legal uncertainty. Addressing these conflicts often requires novel approaches, including international cooperation, harmonization of laws, and the development of new legal doctrines tailored to the digital environment. Unification and standardization of cyber law. The global nature of cyberspace necessitates efforts towards unification and standardization of cyber law. International organizations like UNCITRAL have developed model laws on electronic commerce. Regional initiatives, such as the EU's Digital Single Market Strategy, aim to create harmonized rules across member states. The Budapest Convention represents a significant effort to standardize cybercrime laws internationally. Standardization extends beyond formal legal instruments to technical standards developed by organizations like the IETF and W3C. However, challenges remain in achieving global unification due to differing legal traditions, national interests, and rapid technological change. The ongoing process aims to create a more coherent and effective global framework for cyber law. The place of cyber law in the legal system and its interaction with other branches of law and scientific disciplines. Cyber law intersects with numerous traditional legal branches and scientific disciplines. It interacts with constitutional law in areas like online expression and digital privacy. Criminal law has adapted to address cybercrime. Contract and tort law have evolved to accommodate digital transactions and harms. Intellectual property law has undergone significant changes to address digital challenges. Beyond legal disciplines, cyber law interacts closely with computer science, particularly in digital forensics and cybersecurity. It also engages with social sciences, considering the societal impacts of digital technologies. This interdisciplinary nature reflects the complex interplay between technology, society, and legal frameworks in the digital age. In this section, we've explored the fundamental aspects of cyber law, from its origins to its place in the broader legal system. As we've seen, cyber law is a dynamic field that continues to evolve in response to technological advancements and societal changes. Its multifaceted nature requires ongoing adaptation and interdisciplinary approaches to effectively govern the digital realm. Digital sovereignty in the age of cyberspace. Dear listeners, now, let's begin our new section. In this part, we'll explore the concept of digital sovereignty and its implications in the age of cyberspace. We'll examine how traditional notions of state authority are being reshaped by digital technologies and the emergence of cyber law as a response to these new challenges. Digital sovereignty of states, concept, principles, and mechanisms of assurance. Digital sovereignty refers to a state's ability to govern its digital space, including control over data, technology, and regulatory frameworks. Key principles include data sovereignty, technological independence, and cyber capabilities. The concept has gained importance due to its implications for national security and economic development in an interconnected world. Mechanisms for assuring digital sovereignty include data localization laws, development of national tech industries, and cyber defense strategies. However, the borderless nature of cyberspace presents significant challenges to traditional notions of sovereignty. Balancing digital sovereignty with international cooperation and the free flow of information remains a key challenge for policymakers. Digital public administration, e-public administration concept, principles, and models. E-public administration represents the transformation of government operations through digital technologies. It encompasses e-services, e-management, e-democracy, and e-policy. Key principles include digital by default, once only, and inclusiveness. The UN E-Government Development Index serves as a global benchmark for progress in this area. Models of e-public administration range from digitizing existing processes to complete digital transformation of public services. Components include digital ID systems, government cloud services, online voting systems, and digital economy legislation. This transformation is driven by the need for efficiency, transparency, and citizen centricity in governance. E-government, architecture, functions, and development stages. E-government architecture typically includes front-end, citizen-facing, and back-end, administrative, systems, connected through interoperability frameworks. Functions cover G2C, government to citizen, G2B, government to business, and G2G, government to government, interactions. These systems aim to provide seamless, integrated services to citizens and businesses. Development stages often follow models like the World Bank's, progressing from web presence to transactional services, and ultimately to digital transformation. Key challenges include ensuring universal access, maintaining data security, and fostering digital literacy among citizens and government employees. Successful e-government implementation can lead to increased efficiency, reduced corruption, and improved citizen satisfaction. Electronic government services, TGov service classification, quality standards, and effectiveness evaluation. TGov services encompass a wide range of digital services provided by governments to citizens and businesses. These can be classified based on their level of sophistication, from information provision to fully transactional services. Quality standards for these services often focus on accessibility, usability, security, and privacy protection. Effectiveness evaluation of TGov services involves measuring user satisfaction, adoption rates, cost savings, and impact on government efficiency. Key performance indicators may include the number of services available online, time saved for citizens, and reduction in administrative burdens. Regular assessments and user feedback mechanisms are crucial for continuous improvement of these services. Electronic document management, (eDoc), in public administration, legal and technological aspects. eDoc systems in public administration involve the creation, storage, and management of digital documents throughout their lifecycle. Legal aspects include ensuring the validity and admissibility of electronic documents, establishing digital signature frameworks, and complying with data protection regulations. These systems must adhere to standards for long-term preservation and accessibility of public records. Technological solutions for eDoc include document management systems, digital archiving solutions, and workflow automation tools. Key challenges involve ensuring interoperability between different government agencies, maintaining document integrity and authenticity over time, and balancing open access with necessary confidentiality. Successful implementation can lead to significant improvements in administrative efficiency and transparency. Industry 4.0 in the public sector, smart city, smart grid, legal and technological aspects. Industry 4.0 concepts are increasingly applied in the public sector, particularly in smart city initiatives and smart grid implementations. Smart cities leverage IoT, big data, and AI to optimize urban services and improve quality of life. Smart grids enhance energy distribution efficiency and enable better integration of renewable energy sources. Legal aspects include data protection regulations, privacy concerns, and liability issues in automated systems. Technological challenges involve ensuring interoperability, cybersecurity, and scalability of these complex systems. The implementation of Industry 4.0 in the public sector requires careful consideration of ethical implications and potential societal impacts. E-elections and e-democracy, opportunities and risks. E-elections and e-democracy initiatives aim to increase citizen participation in democratic processes through digital technologies. These include online voting systems, digital public consultations, and e-petitioning platforms. Opportunities include increased accessibility, potentially higher participation rates, and more direct forms of democracy. However, these systems also present significant risks, including cybersecurity threats, potential for election manipulation, and challenges in ensuring voter anonymity and verifiability. Legal frameworks must address issues of digital identity verification, vote secrecy, and the audit trail of electronic votes. Balancing the benefits of increased participation with the need for election integrity remains a key challenge. Artificial intelligence in public administration, legal aspects of use and regulation. AI applications in public administration range from chatbots for citizen services to predictive analytics for policymaking. These technologies offer potential for increased efficiency and data-driven decision-making. However, they also raise significant legal and ethical questions, particularly regarding transparency, accountability, and potential bias. Regulatory frameworks for AI in public administration must address issues of algorithmic fairness, explainability of AI decisions, and human oversight. Data protection regulations play a crucial role in governing the use of personal data in AI systems. As AI becomes more prevalent in government operations, ensuring its responsible and ethical use becomes increasingly important. E-procurement, enhancing transparency and efficiency in government procurement. E-procurement systems digitize government purchasing processes, aiming to increase transparency, reduce corruption, and improve efficiency. These systems typically include e-tendering, e-auctions, and contract management functionalities. Legal frameworks for e-procurement must ensure fair competition, prevent collusion, and maintain the integrity of the procurement process. Technological aspects involve ensuring system security, interoperability with financial systems, and accessibility for all potential suppliers. Challenges include ensuring digital literacy among suppliers, particularly small businesses, and maintaining system integrity against cyber threats. Successful e-procurement implementation can lead to significant cost savings and increased trust in government operations. International experience in e-government implementation, comparative analysis and best practices. E-government implementation varies significantly across countries, reflecting different political systems, technological capabilities, and cultural contexts. Leading examples include Estonia's Digital Society Initiative, Singapore's Smart Nation program, and the UK's Government Digital Service. Comparative analysis reveals common success factors such as strong political leadership, citizen-centric design, and robust digital infrastructure. Best practices include adopting a whole-of-government approach, prioritizing interoperability and open standards, and fostering public-private partnerships. Challenges common across countries include digital divide issues, resistance to change within bureaucracies, and balancing innovation with data protection. Learning from international experiences can help countries at different stages of e-government development to accelerate their digital transformation journeys. In this part, we've explored the multifaceted concept of digital sovereignty and its manifestation through various e-government initiatives. From the overarching principles of digital sovereignty to specific applications like e-procurement and AI in public administration, we've seen how digital technologies are reshaping governance in the 21st century. As states continue to navigate the challenges and opportunities of the digital age, the development of robust legal frameworks and technological solutions will be crucial in ensuring effective, transparent, and citizen-centric governance. Economics and cyber law, legal regulation of digital economic transformation. Let's delve into the next section, when we'll explore the intersection of economics and cyber law in the context of digital economic transformation. We'll examine how legal frameworks are adapting to new digital business models, financial technologies, and the challenges they present to traditional economic regulations. Digital and platform economy, concept, features, and legal aspects. The digital economy, conceptualized in the 1990s, encompasses economic activities facilitated by digital technologies. Platform economics, a subset of this, is characterized by digital platforms mediating user interactions. These models have transformed traditional industries, as seen in retail, Amazon, transportation, Uber, and hospitality, Airbnb. Legal challenges in this domain include competition law issues, labor regulations for gig workers, and consumer protection in digital markets. The ecosystem involves platform providers, users, regulators, and traditional businesses navigating a rapidly evolving technological and legal landscape. Legal regime of digital assets, classification, circulation, and taxation. Digital assets, encompassing cryptocurrencies, tokens, and digital securities, challenge traditional legal frameworks. Their classification varies across jurisdictions, impacting regulatory approaches. The circulation of these assets raises questions about ownership, transfer mechanisms, and security interests. Taxation of digital assets is a complex issue, with authorities worldwide grappling with how to categorize and tax these new forms of value. The anonymity and borderless nature of many digital assets complicate enforcement efforts, necessitating new approaches to financial regulation and international cooperation. Electronic commerce, e-commerce models, tools, and legal regulation. E-commerce has revolutionized retail and business transactions. Various models exist, including B2B, B2C, C2C, and emerging models like social commerce. Legal frameworks must address issues such as electronic contracts, digital signatures, consumer protection in online transactions, and cross-border e-commerce disputes. Key legal instruments include the UNCITRAL Model Law on Electronic Commerce and various national e-commerce laws. Challenges include adapting traditional contract law to digital contexts, ensuring data protection in online transactions, and addressing jurisdictional issues in global e-commerce. Electronic corporate governance, e-governance principles, mechanisms, and effectiveness. E-governance in the corporate sector involves using digital technologies for shareholder communications, board meetings, and corporate compliance. Key principles include transparency, accessibility, and security. Mechanisms include electronic voting systems, digital reporting tools, and blockchain-based shareholder registries. Legal considerations involve ensuring the validity of virtual shareholder meetings, protecting shareholder rights in digital environments, and maintaining data integrity in corporate records. The effectiveness of e-governance is measured by improved shareholder engagement, reduced costs, and enhanced transparency. Legal regulation of financial technologies, fintech models and instruments. Fintech encompasses a wide range of innovative financial services, including digital banking, peer-to-peer lending, and robo-advisors. Regulatory approaches vary, with some jurisdictions adopting regulatory sandboxes to foster innovation while managing risks. Key legal issues include consumer protection, data security, and maintaining financial stability. Instruments for regulating fintech include specific fintech laws, adaptations of existing financial regulations, and self-regulatory industry standards. The challenge lies in balancing innovation with consumer protection and systemic risk management in rapidly evolving financial technologies. Smart contracts, smart tech concept, characteristics, application areas, and legal aspects of use. Smart contracts are self-executing agreements with terms written into code. They offer potential for increased efficiency and reduced intermediation in various sectors. Key characteristics include automation, transparency, and immutability. Application areas include finance, supply chain management, and real estate. Legal aspects involve questions of contract formation, enforcement, and dispute resolution. Challenges include ensuring legal recognition of smart contracts, addressing coding errors, and determining liability in automated transactions. The intersection of smart contracts with traditional contract law principles remains an area of ongoing legal development. Cyber insurance, concept, characteristics, application areas, and legal aspects of use. Cyber insurance has emerged as a critical risk management tool for businesses in the digital age. It typically covers losses from data breaches, business interruption due to cyber attacks, and liability arising from data protection failures. Key characteristics include the dynamic nature of cyber risks and the challenges in risk assessment. Legal aspects involve policy wording and interpretation, determining causation in complex cyber incidents, and jurisdictional issues in global cyber events. The evolving nature of cyber threats necessitates continuous adaptation of cyber insurance products and associated legal frameworks. Antitrust regulation in the digital economy, e-antitrust concept, characteristics, application areas, and legal aspects of use. E-antitrust addresses competition issues unique to digital markets, such as network effects, data-driven market power, and platform economics. Key concepts include multi-sided markets, zero-price services, and data as a competitive asset. Application areas include tech giants' market dominance, merger control in digital markets, and algorithmic collusion. Legal challenges involve adapting traditional antitrust concepts like market definition and abuse of dominance to digital contexts. Cases like the EU's Google shopping decision highlight the complex interplay between innovation, consumer welfare, and fair competition in digital markets. Taxation in the digital economy, e-taxation concept, characteristics, application areas, and legal aspects of use. E-taxation addresses the challenges of applying tax systems designed for physical economies to digital business models. Key issues include determining taxable presence in the digital realm, valuing data and user contributions, and preventing tax base erosion in the digital economy. International efforts, such as the OECD's work on base erosion and profit shifting, BEPS, aim to create a coherent global approach to digital taxation. Legal aspects involve redefining permanent establishment for digital businesses, implementing digital services taxes, and ensuring fair taxation of multinational tech companies. Consumer protection in the digital environment, e-consumer protection tools and mechanisms. E-consumer protection adapts traditional consumer rights to the digital marketplace. Key areas include protecting consumers in online transactions, addressing digital content issues, and ensuring transparency in e-commerce practices. Tools include online dispute resolution mechanisms, digital rights management systems, and consumer education initiatives. Legal mechanisms involve updating consumer protection laws for the digital age, enforcing transparency in online pricing and advertising, and protecting consumer data in digital transactions. Challenges include addressing cross-border consumer disputes and regulating emerging technologies like AI in consumer interactions. This section has explored the complex interplay between economics and cyber law in the context of digital transformation. From the emergence of new digital assets and business models to the challenges of applying traditional legal concepts in the digital realm, we've seen how legal frameworks are evolving to address the unique characteristics of the digital economy. As technology continues to reshape economic activities, the ongoing development of adaptive, innovative legal approaches will be crucial in ensuring a fair, secure, and thriving digital economic landscape. Legal framework of information infrastructure. Dear listeners, in our next part, we delve into the legal framework governing information infrastructure in the digital age. We'll explore how traditional legal concepts are adapting to emerging technologies and the new challenges they present. Legal regulation of information infrastructure, objects, subjects, regimes. Information infrastructure encompasses interconnected systems facilitating data flow in society. Legal regulation is crucial for its proper functioning and protection. Key concepts include network neutrality, critical information infrastructure, and digital sovereignty. International documents like the ITU's Global Cybersecurity Agenda provide foundational frameworks. Regulation can be conceptualized through physical, logical, and content layers, each requiring tailored legal approaches. As technologies like 5G and IoT emerge, legal frameworks must adapt to new challenges while balancing innovation, security, and individual rights. The Budapest Convention on Cybercrime serves as a cornerstone for international cooperation in this domain. Artificial intelligence, AI concept, types, and legal aspects of regulation. AI systems simulate human cognitive functions, evolving from narrow to general AI. The EU's White Paper on AI highlights its role in addressing societal challenges and economic growth. AI's advancement raises legal and ethical debates on data privacy, algorithmic bias, liability, and autonomous decision-making. Key regulations include the EU's AI Act, 2024, and the OECD AI Principles. Legal challenges involve determining liability for AI decisions, protecting AI-generated intellectual property, and ensuring algorithmic transparency. The debate over AI legal personhood continues, with implications for accountability and rights. The IEEE's ethically aligned design provides guidelines for responsible AI development. Blockchain technology, essence, application areas, and legal issues of use. Blockchain, introduced by Satoshi Nakamoto in 2008, is a distributed ledger enabling secure, transparent record-keeping without central authority. Its applications extend beyond cryptocurrencies to smart contracts and decentralized applications. Legal challenges include regulatory classification of crypto assets, smart contract enforceability, and data protection compliance. The EU's Markets in Crypto Assets, MiCA, regulation aims to provide a comprehensive framework for crypto assets. The Howey test in the US influences the classification of tokens as securities. Legal frameworks must address issues of jurisdiction, liability, and dispute resolution in decentralized systems. The UNCITRAL Model Law on Electronic Transferable Records provides guidance for blockchain-based transactions. Legal regulation of robotics and unmanned aerial vehicles, drones. Robotics and drone technologies present unique regulatory challenges. Key areas include safety standards, liability frameworks, and privacy protection. The EU's Machinery Directive and the US FAA regulations for drones provide foundational rules. Emerging issues involve autonomous systems decision-making liability and the use of drones for surveillance. International efforts like the Tallinn Manual 2.0 address the application of international law to cyber operations, including those involving autonomous systems. Privacy concerns are addressed through regulations like the EU's GDPR, particularly regarding data collected by drones. The development of a comprehensive legal framework for robotics remains an ongoing challenge. Internet of Things, IoT architecture, security, and legal aspects of functioning. IoT connects everyday devices to the Internet, raising concerns about data security and privacy. Legal frameworks must address issues of data ownership, consent in pervasive computing environments, and liability for IoT device failures. The EU's Cybersecurity Act provides a certification framework for IoT devices. Security standards like ISO/IEC 27001 and the NIST Cybersecurity Framework guide IoT security practices. Privacy challenges are addressed through regulations like GDPR and the California Consumer Privacy Act. The ITU-TSY 2060 recommendation provides a reference model for IoT, influencing legal and technical standards globally. Digital twins, concept, purpose, and legal regime of use. Digital twins are virtual representations of physical objects or systems, used for monitoring, analysis, and optimization. Legal considerations include data ownership, liability for decisions based on digital twin models, and intellectual property rights for digital twin designs. The concept intersects with regulations on IoT, AI, and data protection. While no specific legislation exists for digital twins, their use is governed by existing data protection laws, intellectual property regulations, and industry-specific standards. The EU's proposed Data Act addresses aspects of data sharing that are relevant to digital twin applications. Standards like ISO/IEC 21823-1:2019 guide the interoperability of IoT systems, including digital twins. Big data and cloud technologies, legal aspects of data collection, processing, and storage. Big data and cloud computing present challenges in data protection, privacy, and cross-border data flows. Key regulations include GDPR in the EU and the Cloud Act in the US. Legal issues involve data localization requirements, the right to be forgotten in big data contexts, and liability in cloud service ecosystems. The EU-US Privacy Shield framework, though invalidated, highlighted the complexities of international data transfers. Cloud security standards like ISO/IEC 27017 guide compliance efforts. The OECD Privacy Guidelines provide an international framework for data protection principles applicable to big data and cloud technologies. Cyber-physical systems, features and problems of legal regulation. Cyber-physical systems, CPS, integrate computation, networking, and physical processes, posing unique legal challenges. Regulatory frameworks must address safety, security, and privacy in interconnected systems. The US NIST framework for cyber-physical systems provides guidance on CPS architecture and analysis. Legal issues include liability for autonomous CPS decisions, data protection in pervasive sensing environments, and regulatory approval for CPS in critical sectors like healthcare and transportation. The EU's NIS directive addresses cybersecurity of critical infrastructure, including many CPS applications. Standards like IEC 61508 guide functional safety aspects of CPS. Neurotechnology, ethical and legal issues of development and application. Neurotechnology raises profound ethical and legal questions about mental privacy, cognitive liberty, and human enhancement. While specific neurotechnology laws are scarce, existing regulations on medical devices and human subject research apply. The OECD recommendation on responsible innovation in neurotechnology provides ethical guidelines. Key legal issues include protecting neurorights, regulating brain-computer interfaces, and addressing liability for actions influenced by neurotechnology. Chile's constitutional reform to protect cerebral integrity represents a pioneering legal approach to neurotechnology. Data protection laws like GDPR have implications for the collection and use of neural data. Quantum computing, potential, risks, and legal aspects of use. Quantum computing promises revolutionary computational power but poses significant risks to current cryptographic systems. Legal frameworks must address quantum-resistant cryptography, data protection in the quantum era, and the implications for digital signatures and secure communications. The U.S. National Quantum Initiative Act and the EU's Quantum Flagship Program demonstrate government efforts to advance quantum technologies while addressing potential risks. The NIST Post-Quantum Cryptography Standardization Project aims to develop quantum-resistant cryptographic standards. Legal considerations include updating regulations on electronic signatures and adapting cybersecurity laws to quantum computing realities. This section has explored the complex legal landscape surrounding modern information infrastructure. From AI and blockchain to neurotechnology and quantum computing, we've seen how emerging technologies challenge existing legal frameworks and necessitate new approaches. As these technologies continue to evolve, so too must the legal and regulatory environment, striking a balance between fostering innovation and protecting individual rights and societal interests in the digital age. Personal data protection in the digital age. In this chapter, we'll explore the critical issue of personal data protection in the digital era. We'll examine how traditional privacy concepts have evolved to address the challenges posed by modern data processing technologies and practices. Foundations and principles of personal data protection. Personal data protection has become a fundamental right in many jurisdictions. The EU's General Data Protection Regulation, GDPR, sets a global benchmark, defining personal data broadly and establishing key principles such as lawfulness, fairness, and transparency. The OECD Privacy Guidelines provide an international framework for data protection. These principles aim to balance individuals' rights with the needs of data processors in our data-driven world. The scope of data protection laws has expanded to address borderless digital data flows, presenting challenges in enforcement across jurisdictions. Cases like Schrems v. Facebook Ireland Ltd. have shaped the interpretation of these principles in practice. Organizational and legal measures for personal data security, standards and best practices. Organizations must implement both technical and organizational measures to ensure data security. The ISO/IEC 27001 standard provides a framework for information security management systems. Legal requirements, such as GDPR's Article 32, mandate appropriate security measures based on risk assessment. Best practices include data encryption, access controls, regular security audits, and employee training programs. The concept of privacy by design has gained traction, emphasizing the integration of privacy considerations throughout the system development lifecycle. Compliance with these measures is often demonstrated through certifications and seals, providing assurance to data subjects and regulators. Rights and obligations of personal data subjects, specifics of implementation in the digital environment. Data subjects have been granted comprehensive rights under modern data protection laws. These include the right to access, rectification, erasure, the right to be forgotten, and data portability. The implementation of these rights in the digital environment presents unique challenges, such as verifying the identity of requesters in online contexts. Obligations of data controllers include providing clear and accessible privacy notices, obtaining valid consent, and responding to data subject requests within specified timeframes. The case of Google Spain SLV, AEPD and Mario Casteja Gonzalez established the right to be forgotten in the EU, demonstrating the far-reaching implications of these rights in the digital age. Cross-border transfer of personal data, conditions, restrictions, and protection mechanisms. The global nature of data flows necessitates mechanisms for international data transfers. The EU-US Privacy Shield framework, before its invalidation by the Schrems II decision, was a key mechanism for transatlantic data flows. Currently, standard contractual clauses, SCCs, and binding corporate rules, BCRs, are primary tools for ensuring adequate protection in cross-border transfers. Restrictions on data transfers to countries without adequate protection levels aim to ensure consistent data protection standards globally. The Asia-Pacific Economic Cooperation (APEC) Cross-Border Privacy Rules (CBPR) system offers an alternative framework for facilitating data flows while protecting privacy. These mechanisms must balance data protection with the need for global data mobility in the digital economy. Liability for violations of personal data legislation, types and grounds for application. Data protection laws impose significant penalties for non-compliance. Under GDPR, fines can reach up to €20 million or 4% of global annual turnover, whichever is higher. The types of liability include administrative fines, compensation to data subjects, and in some cases, criminal penalties for severe breaches. Grounds for liability include unauthorized data processing, security breaches, and failure to comply with data subject rights. Notable cases, such as the €50 million fine imposed on Google by the French Data Protection Authority, CNIL, demonstrate the seriousness with which violations are treated. The concept of joint controllership, as established in cases like Fashion ID GmbH Company, KGV Verbraucherzentrale NRW-EV, has expanded the scope of liability in complex data processing scenarios. Copyright in the digital age, new objects, usage models, and protection. Digital technologies have transformed copyright law, introducing new forms of creative expression and distribution methods. The WIPO Copyright Treaty, WCT, and WIPO Performances and Phonograms Treaty, WPPT, address these challenges at the international level. Issues include the copyright status of user-generated content, AI-created works, and the application of fair use doctrine in digital contexts. New usage models, such as streaming and cloud computing, challenge traditional concepts of reproduction and distribution rights. Digital rights management (DRM) systems, protected under laws like the U.S. Digital Millennium Copyright Act (DMCA), have become contentious. Cases like Authors Guild v. Google Incorporated have shaped the interpretation of fair use in the digital age, particularly regarding mass digitization projects. Legal protection of software, regimes, registration, and licensing. Software protection involves a complex interplay of copyright, patent, and trade secret law. The EU Software Directive harmonizes copyright protection for computer programs in Europe. Patent protection for software-related inventions varies globally, with the US generally more permissive than the EU. Open-source licensing models, such as the GNU General Public License, GPL, have gained prominence, challenging traditional software licensing paradigms. Cases like Oracle America Incorporated v. Google LLC have addressed the copyrightability of software interfaces. The legal status of software as a service, SaaS, and cloud-based software distribution continues to evolve, raising questions about exhaustion of rights and cross-border licensing. Patenting in information technology, peculiarities and limitations. Patenting in IT faces unique challenges due to the abstract nature of software and the rapid pace of innovation. The patentability of software and business methods varies across jurisdictions. In the US, the Alice Corp. v. CLS Bank International decision set a framework for determining patent eligibility of software-related inventions. Standard Essential Patents, SEPs, play a crucial role in IT standardization, with FRAND, fair, reasonable, and non-discriminatory licensing terms being a key issue. Patent trolls and defensive patent aggregators have emerged as significant players in the IT patent landscape. The intersection of patents with open-source software presents ongoing legal and practical challenges for the industry. Intellectual property generated by artificial intelligence, issues of authorship and ownership. AI-generated works challenge traditional notions of authorship and creativity in IP law. Questions arise about whether AI can be considered an author or inventor under current legal frameworks. The case of the Davis patent applications, where an AI system was named as the inventor, highlights these issues. Ownership of AI-generated IP is contentious, with potential claims from AI developers, users, and data providers. Some jurisdictions, like the UK, have specific provisions for computer-generated works, but most legal systems are still grappling with these questions. The economic and ethical implications of AI-generated IP are subjects of ongoing debate and policy consideration. Means of individualization in cyberspace, domain names, meta tags, keywords. Digital identifiers like domain names have become crucial business assets, leading to the development of specific legal frameworks. The Uniform Domain Name Dispute Resolution Policy, UDRP, provides a mechanism for resolving domain name disputes. Trademark law has been extended to cover issues like cyber squatting, as seen in cases like Panavision International v. Topin. The use of trademarks in meta tags and keywords for online advertising has been the subject of numerous legal disputes. The European Court of Justice's decision in Google France SARL v. Louis Vuitton Maladier SA provided guidance on the use of trademarks as keywords in online advertising. These issues highlight the ongoing challenge of applying traditional IP concepts to the dynamic digital environment. This chapter has explored the multifaceted landscape of personal data protection and related intellectual property issues in the digital age. From the fundamental principles of data protection to the emerging challenges posed by AI-generated IP, we've seen how legal frameworks are adapting to technological advancements. As digital technologies continue to evolve, the law must strike a balance between protecting individual rights, fostering innovation, and addressing the unique characteristics of the digital environment. The ongoing development of these legal frameworks will play a crucial role in shaping our digital future. Cybercrime in the digital age. Let's talk about the next part, which explores cybercrime, examining its concepts, types, and legal responses. We'll delve into the challenges of combating digital crimes and the evolving strategies to address them. Cybercrime, concept, types, and criminal law characteristics. Cybercrime encompasses criminal activities using computers or the internet. It includes cyber-dependent crimes like hacking, and cyber-enabled crimes like online fraud. The Budapest Convention on Cybercrime provides a framework for addressing these offenses. The UN Office on Drugs and Crime estimates that cybercrime costs the global economy up to $1.5 trillion annually. Cybercrime's unique characteristics, including its borderless nature and potential for anonymity, complicate traditional law enforcement approaches. The transnational aspect often creates jurisdictional issues, necessitating international cooperation. Cybercrime's rapid evolution challenges legal systems to keep pace, with new forms of digital crime emerging regularly. Cyberterrorism, concept, forms, and criminal law countermeasures. Cyberterrorism involves using digital technologies to create fear, cause disruption, and advance political agendas. It challenges traditional security notions, blurring lines between cybercrime and terrorism. The 2015 Ukraine power grid cyber attack exemplifies its potential impact. Cyber-terrorists may target critical infrastructure, financial systems, or government networks. Legal responses include adapting existing counterterrorism laws and developing new frameworks. International cooperation is crucial, with initiatives like the UN Global Counterterrorism Strategy addressing cyber threats. Balancing security measures with civil liberties remains a key challenge. The Council of Europe's Committee of Experts on Terrorism provides guidance on legal approaches to cyberterrorism. Criminal law measures to counter cybercrime, national and international levels. National measures include comprehensive cybercrime legislation, specialized law enforcement units, and public-private partnerships. The US Computer Fraud and Abuse Act and UK's Computer Misuse Act are examples of national frameworks. Many countries have established dedicated cybercrime units within their law enforcement agencies. Internationally, the Budapest Convention provides a comprehensive legal framework for cybercrime. Regional efforts, like the African Union Convention, complement global initiatives. Challenges include harmonizing laws across jurisdictions and addressing emerging cyber threats. The UN's Intergovernmental Expert Group on Cybercrime works towards developing international standards. Electronic evidence, e-evidence concept, types, and peculiarities of collection and examination. E-evidence includes data from computers, networks, and digital devices. Types range from email communications to metadata. The volatile nature of digital evidence necessitates specialized collection techniques. The Council of Europe's Electronic Evidence Guide provides best practices for handling digital evidence. Legal frameworks are adapting to address e-evidence challenges. The EU's e-evidence digital exchange system aims to streamline cross-border evidence gathering. Challenges include maintaining the chain of custody and ensuring admissibility in court. The U.S. Federal Rules of Evidence have been updated to address electronic evidence specificities. Cybercriminology, factors of cybercrime and characteristics of cybercriminals. Cybercriminology examines factors contributing to cybercrime, including technological, psychological, and sociological aspects. It adapts traditional criminological theories to the digital context, such as applying routine activity theory to online behaviors. The dark triad personality traits are often associated with certain types of cybercriminal behavior. Cybercriminal profiles vary widely, from lone hackers to organized crime groups. Understanding these profiles and motivations is crucial for developing effective prevention and response strategies. The anonymity of cyberspace presents unique challenges in studying offender characteristics. Cybercriminology also explores the impact of online subcultures on criminal behavior. Digital forensics, methods and tools for investigating cybercrimes. Digital forensics involves collecting, analyzing, and preserving electronic evidence. Key tools include forensic imaging software, network analysis tools, and data recovery programs. Techniques must adhere to legal standards to ensure evidence admissibility. The ACPO Good Practice Guide for Digital Evidence provides guidelines for UK law enforcement. Challenges include dealing with encryption, cloud storage, and the increasing volume of data. The rapidly evolving nature of technology requires constant updating of forensic methods. International standards, like ISO/IEC 27037, guide digital evidence handling practices. Advanced techniques like memory forensics and network forensics are becoming increasingly important. Artificial intelligence in combating cybercrime, possibilities and legal limitations. AI offers powerful tools for detecting and preventing cybercrime, including anomaly detection and predictive analytics. Machine learning algorithms can analyze vast amounts of data to identify patterns indicative of criminal activity. AI-powered threat intelligence platforms enhance cybersecurity defenses. However, AI use in law enforcement raises legal and ethical concerns. Issues include potential bias in AI systems, privacy implications of data analysis, and the need for human oversight. Balancing AI's potential with legal safeguards remains a key challenge. The EU's AI Act addresses the use of AI in law enforcement contexts. International cyber criminal process, legal foundations, subjects, and cooperation mechanisms. The international cyber criminal process involves complex jurisdictional and cooperation issues. Key mechanisms include mutual legal assistance treaties, MLATs, and extradition agreements. The Budapest Convention provides a framework for international cooperation. Interpol's Global Complex for Innovation supports international cybercrime investigations. Challenges include differences in national laws, difficulties in attributing cyber attacks, and the need for rapid response to volatile digital evidence. Initiatives like the 24/7 network established by the G7 aim to facilitate timely cooperation in cybercrime investigations. The UN Office on Drugs and Crime provides technical assistance to countries in developing cybercrime legislation. Qualification and investigation of cybercrimes. Qualifying cybercrimes involves applying legal definitions to digital offenses, often challenging due to technological complexities. Investigations require specialized skills in digital forensics and online intelligence gathering. Many countries have established specialized cybercrime units within their law enforcement agencies. Key investigative techniques include IP tracing, malware analysis, and open-source intelligence, OSINT. Challenges include dealing with anonymizing technologies and jurisdictional issues. Cooperation between law enforcement and the private sector is often crucial for successful investigations. The European Cybercrime Center, EC3, at Europol provides support for complex cross-border investigations. International legal assistance in criminal cases of cybercrime. International legal assistance is vital for addressing the global nature of cybercrime. The Budapest Convention provides mechanisms for mutual assistance and information sharing. Regional initiatives, like Europol's EC3, facilitate operational cooperation. The UNODC's global program on cybercrime supports capacity building in developing countries. Challenges include differences in legal systems, data protection laws affecting information sharing, and the need for rapid assistance in time-sensitive cases. Efforts to streamline assistance processes, like the EU's e-evidence proposal, aim to address these challenges. The G7 24/7 network provides a platform for expedited cooperation in urgent cybercrime cases. This section has explored the multifaceted nature of cybercrime and the diverse strategies employed to combat it. From legal frameworks to technological tools, the fight against cybercrime requires a comprehensive, adaptive approach that balances effective law enforcement with the protection of individual rights in the digital age. Legal advocacy in the digital age. Dear listeners, our next section explores how digital technologies are transforming legal advocacy, presenting new opportunities and challenges for legal practitioners in the modern era. E-advocacy, new opportunities and ethical issues. E-advocacy leverages digital technologies to enhance legal services, including online consultations, digital submissions, and AI-assisted research. The ABA model rules address ethical considerations in digital practice, emphasizing technological competence. Virtual law firms and cloud-based practice management systems are reshaping legal service delivery. Challenges include maintaining client confidentiality in digital communications, ensuring equal access to justice, and navigating the ethical implications of AI in legal practice. The COVID-19 pandemic accelerated e-advocacy adoption, highlighting its importance and revealing disparities in digital access among legal professionals and clients. Prosecutorial supervision of law enforcement in cyberspace, e-prosecutorial supervision objects, powers, and response measures. E-prosecutorial supervision oversees cybercrime investigations and digital evidence collection, requiring understanding of digital forensics and cybercrime jurisdiction. The Budapest Convention provides a framework for international cooperation, while national laws like the U.S. Cloud Act address cross-border data access. Prosecutors face challenges in applying traditional legal principles to digital contexts, such as determining jurisdiction in cloud-stored data cases. Their role includes ensuring the legality of electronic surveillance, guiding law enforcement in digital evidence handling, and addressing novel legal questions raised by emerging technologies like cryptocurrency and IoT devices. Cyber police, structure, tasks, and methods of combating cybercrime. Cyber police units specialize in investigating digital crimes, employing advanced digital forensics tools and techniques. Interpol's Global Complex for Innovation facilitates international cooperation, providing resources and training for member countries. National units like the FBI's Cyber Division in the US and the UK's National Cyber Crime Unit lead domestic efforts. Tasks include investigating cyber crimes, collecting digital evidence, conducting undercover online operations, and collaborating with international partners. Methods evolve rapidly to keep pace with cybercriminal tactics, incorporating AI, big data analytics, and blockchain analysis tools. Challenges include staying ahead of rapidly evolving cyber threats and addressing jurisdictional issues in transnational cybercrimes. Specialized high-tech crime units of law enforcement agencies, international experience. Many countries have established dedicated cybercrime units, with the FBI's Cyber Division and UK's National Cyber Crime Unit as prominent examples. These units often collaborate internationally through frameworks like Europol's EC3, which facilitates information sharing and joint operations across EU member states. Specialized training and continuous skill development are crucial, with many units partnering with academic institutions and private sector experts. Units face challenges in recruiting and retaining skilled personnel in competition with the private sector, often leading to innovative partnerships and secondment programs. The rapid evolution of technology necessitates constant adaptation of training programs and operational methodologies. Operational and investigative activities in cyberspace, legal grounds, forms, and methods. Cybercrime investigations involve unique operational activities, with legal frameworks like the US ECPA governing electronic surveillance. Undercover operations in cyberspace present novel legal and ethical challenges, particularly regarding entrapment and privacy rights. The Council of Europe's Cybercrime Convention Committee provides guidelines for law enforcement activities in cyberspace. Methods include IP tracing, malware analysis, open-source intelligence gathering, and cryptocurrency tracing. Balancing effective investigation with privacy rights remains a key challenge, especially in cases involving encryption and anonymizing technologies. International cooperation is often crucial, facilitated by frameworks like the G7 24/7 Network for Cybercrime. Application of IT technologies in law enforcement activities, spheres and legal aspects. Law enforcement increasingly relies on advanced technologies, with AI and machine learning enhancing data analysis capabilities. Predictive policing algorithms raise ethical concerns and potential bias issues. Challenges include ensuring the admissibility of technologically derived evidence and maintaining transparency in AI-assisted decision-making processes. Legal frameworks are adapting to address new technologies' use, with the EU's AI Act aiming to regulate AI use in law enforcement. Body-worn cameras, facial recognition technology, and big data analytics present both opportunities and legal challenges, particularly regarding privacy rights and data protection. The use of these technologies often requires careful balancing of public safety interests with individual rights. E-enforcement, electronic execution of judicial decisions and law enforcement acts. E-enforcement leverages digital technologies for executing court orders, including online asset tracing and digital garnishment. The EU's e-Justice portal facilitates cross-border enforcement of judgments. Challenges include identifying and seizing digital assets like cryptocurrencies, which often require specialized knowledge and international cooperation. Legal frameworks are evolving to address digital enforcement methods, with the Hague Convention on the Recognition and Enforcement of Foreign Judgments in Civil or Commercial Matters considering digital aspects. Smart contracts and blockchain technology offer potential for automated enforcement but raise complex legal questions. E-enforcement also faces challenges in ensuring due process and protecting privacy rights in digital execution processes. Cyber hygiene in law enforcement activities, requirements, standards, and implementation measures. Cyber hygiene is crucial for maintaining law enforcement data security, with standards like the NIST cybersecurity framework guiding best practices. Implementation involves regular training, security audits, and robust incident response plans. The EU's NIS directive sets cybersecurity standards for critical sectors, including law enforcement. Challenges include balancing security with operational efficiency and addressing the human factor in cybersecurity. Insider threats require careful management of access controls and monitoring, while also respecting employee privacy rights. Continuous adaptation to evolving cyber threats and emerging technologies is essential for maintaining effective cyber hygiene in law enforcement agencies. Organizational and legal support for digital transformation of law enforcement agencies, international experience, strategies, programs, and roadmaps. Many countries have initiated digital transformation programs for law enforcement, with the EU's Digital Justice Initiative as a prominent example. These efforts often involve comprehensive strategy development, implementation roadmaps, and significant investment in IT infrastructure and training. The U.S. Department of Justice's Digital Transformation Initiative aims to modernize systems and processes across federal law enforcement agencies. Challenges include organizational resistance to change, ensuring interoperability of new systems with existing processes, and addressing privacy and security concerns in digital transformation. Successful programs often involve multi-stakeholder approaches, incorporating input from law enforcement, legal experts, technology specialists, and civil society organizations to ensure balanced and effective digital transformation strategies. International organizations and law enforcement cooperation in combating cybercrime. International cooperation is crucial in addressing transnational cybercrime, with organizations like Interpol and Europol facilitating collaboration. The Budapest Convention provides a framework for legal cooperation, while initiatives like the Global Forum on Cyber Expertise promote capacity building. The United Nations Office on Drugs and Crime, UNODC, plays a key role in developing international strategies against cybercrime. Challenges include jurisdictional issues, differing legal standards across countries, and the need for rapid information exchange in time-sensitive cases. Efforts to streamline cooperation, like Europol's Siena system, aim to enhance effectiveness. The development of MLATs, mutual legal assistance treaties, specifically addressing cybercrime could further improve international cooperation. Balancing national sovereignty with the need for global cybercrime response remains an ongoing challenge in international law enforcement cooperation. The digital transformation of legal advocacy and law enforcement presents significant opportunities and challenges. As technology evolves, legal frameworks and practices must adapt to ensure effective, ethical, and just application of the law in the digital age, while addressing complex issues of privacy, security, and international cooperation. E-judiciary and its impact on modern legal systems. Dear listeners, we are going to the next section. E-judiciary represents the integration of digital technologies into court processes, enhancing efficiency, accessibility, and transparency. This section explores the transformation of judicial systems in the digital age, examining key concepts, technologies, and legal implications of this evolution. Introduction to e-judiciary. E-judiciary encompasses case management, electronic filing, virtual hearings, and data analytics. International organizations like the European Commission for the Efficiency of Justice and the World Bank promote e-judiciary globally. The evolution has progressed from early database systems to AI-assisted decision-making tools. Key components include virtual courts, online case management systems, and digital evidence handling protocols. E-judiciary's transformative potential is evident in overcoming geographical barriers, reducing case backlogs, and enhancing judicial transparency. However, implementation challenges persist, including digital divide issues, cybersecurity concerns, and the need for legal framework adaptations. As courts worldwide embrace digitalization, e-judiciary is redefining justice administration in the 21st century. Electronic justice, e-justice concept, principles, and forms of implementation. E-justice leverages digital technologies to enhance judicial processes, encompassing e-filing, virtual hearings, and AI-assisted legal research. It facilitates electronic case processing and court-party communications. Key principles include access to justice, transparency, efficiency, data protection, and technological neutrality. The EU's e-justice portal exemplifies comprehensive digital justice initiatives. Implementation forms vary, including fully digital courts, hybrid systems, and specialized online tribunals. E-justice aims to make justice more accessible, efficient, and transparent, reflecting a transformative approach to law administration in the digital age. Challenges include ensuring equal access, maintaining procedural fairness, and adapting legal frameworks to digital processes. Evidence in the context of digitalized judicial proceedings, issues of admissibility and reliability of electronic evidence. Digital evidence presents unique challenges in admissibility and reliability. Metadata, crucial in electronic evidence, provides information on authenticity, integrity, and provenance. Legal frameworks, like the US Federal Rules of Evidence and the UK's Practice Direction 31B, address electronic evidence handling. The UNCITRAL Model Law on Electronic Evidence, 2017, provides international guidance. Challenges include maintaining the chain of custody, ensuring data integrity, and interpreting complex digital forensics. Courts grapple with issues like the admissibility of social media evidence and the reliability of AI-generated analysis. Best practices include using hash values for verification and implementing robust digital forensics procedures. The evolving nature of technology necessitates ongoing adaptation of evidentiary rules and procedures. Electronic document management in courts, e-court document management, legal regulation and technological solutions. E-court document management systems transform traditional paper-based processes. Key components include e-filing, digital storage, retrieval, and sharing of court documents. Legal frameworks, such as the U.S. Court Administration and Case Management Act of 2002, provide the basis for electronic court processes. The EU's eIDAS regulation establishes legal recognition of electronic signatures across member states. Technological solutions include content management systems, OCR technology, and blockchain for document integrity. Challenges involve ensuring long-term digital preservation, implementing effective classification systems, and maintaining data security. Metadata management enhances functionality but raises privacy concerns. These systems significantly improve court efficiency and accessibility while presenting new legal and technical challenges. Application of artificial intelligence in judicial activities, areas, risks, and limitations. AI in judicial activities offers opportunities for enhancing efficiency and decision-making. Applications include legal research assistance, case outcome prediction, and automated document analysis. The EU's AI Act incorporates safeguards for AI use in justice systems. Ethical considerations, as outlined in the Council of Europe's European Ethical Charter on the use of AI in judicial systems, are crucial. Risks include algorithmic bias, lack of transparency, and potential erosion of human judgment in judicial processes. Limitations involve the complexity of legal reasoning and the need for contextual understanding. The right to human intervention in automated decision-making is increasingly recognized. Balancing AI's potential benefits with fundamental principles of justice and human rights remains a key challenge in its judicial application. Online dispute resolution, ODR models, platforms, and legal aspects. ODR leverages digital technologies for conflict resolution outside traditional courts. It covers e-commerce, small claims, family conflicts, and cross-border disputes. UNCITRAL technical notes provide international guidelines. ODR extends traditional ADR methods, offering enhanced accessibility and efficiency. Platforms like eBay's Resolution Center handle millions of e-commerce disputes annually. Legal frameworks for ODR are evolving, with the EU's Directive 2013/11/EU establishing a basis for consumer ODR. Challenges include ensuring procedural fairness, addressing jurisdictional issues, and maintaining confidentiality in online environments. The future of ODR likely involves increased AI integration and expansion into more complex dispute types, necessitating ongoing legal and ethical considerations. Alternative dispute resolution in the digital age, EADR, online mediation and online arbitration. EADR adapts traditional ADR methods to the digital realm, focusing on online mediation and arbitration. It utilizes virtual hearing rooms, asynchronous communication tools, and digital signatures. The UNCITRAL Model Law on International Commercial Arbitration provides a foundation for online arbitration. Online mediation platforms offer features for joint sessions, private caucuses, and agreement drafting. Challenges include building rapport in digital settings, ensuring confidentiality, and addressing cross-border enforcement issues. The New York Convention is interpreted to include online arbitration awards. EADR's effectiveness in various dispute types, from family law to international commercial disputes, demonstrates its potential to enhance access to justice and efficiency in conflict resolution. Recognition and enforcement of foreign court decisions in the context of digitalization. Digitalization transforms the recognition and enforcement of foreign judgments. The Hague Convention, 2019, provides a framework for addressing digital challenges. E-judgments, digital authentication, and online enforcement registers streamline processes. Challenges include reconciling different approaches to digital evidence and balancing digitalization with traditional private international law principles. Cybersecurity and fraud prevention are critical in digital recognition and enforcement. Blockchain offers potential for tamper-proof enforcement records. AI-powered fraud detection systems identify anomalies. Regular security audits ensure system resilience. These developments highlight the need for advanced security measures and specialized response strategies to protect the integrity and reliability of digital enforcement systems against evolving cyber threats. Transformation of procedural legislation in the digital age, trends and prospects. Procedural law is adapting to address digital challenges. E-filing and digital case management systems are transforming court operations. Virtual hearings, accelerated by global events, require new procedural safeguards. Digital evidence handling necessitates updates to evidentiary rules. AI in court proceedings raises questions about automated decision-making and due process. Emerging trends include blockchain for secure court records, AI-assisted judicial decision support, and enhanced data analytics for case management. Challenges involve balancing technological efficiency with procedural fairness and adapting centuries-old legal principles to digital realities. The future likely involves a hybrid approach, combining digital innovations with traditional legal safeguards to ensure justice in the digital age. International experience in digitalization of judicial systems, comparative legal analysis. Global approaches to judicial digitalization vary. The USCM/ECF system provides a model for federal e-filing. The EU's e-justice portal facilitates cross-border judicial cooperation. China's internet courts experiment with fully digital adjudication. Estonia's e-justice system pioneers comprehensive AI integration. These diverse approaches reflect different legal traditions, technological capabilities, and policy priorities. Comparative analysis reveals common challenges, including ensuring equal access, maintaining judicial independence, and addressing cybersecurity concerns. Lessons learned include the importance of stakeholder engagement, phased implementation, and continuous adaptation to technological advancements. International cooperation and knowledge sharing are crucial for developing best practices and standards in judicial digitalization. It's neat to notice that e-judiciary represents a paradigm shift in justice administration, offering unprecedented opportunities for enhancing access, efficiency, and transparency. As we've explored, from AI integration to online dispute resolution, the digital transformation of judicial systems is comprehensive and far-reaching. While challenges remain, particularly in balancing technological innovation with fundamental principles of justice, the trajectory towards increasingly digitalized court systems appears irreversible. The future of e-judiciary will likely see further integration of emerging technologies, requiring ongoing adaptation of legal frameworks and judicial practices to ensure fair and effective justice delivery in the digital age. Cybersecurity, legal foundations and implementation mechanisms. Our next section will be dedicated to the cybersecurity. Cybersecurity has become a critical concern in our interconnected digital world. This section explores the legal foundations and implementation mechanisms of cybersecurity, examining key concepts, strategies, and challenges in protecting digital assets and infrastructure. Cybersecurity, concept, principles, and general characteristics. Cybersecurity encompasses tools, policies, and practices protecting cyber environments and assets. It addresses threats like malware, phishing, and DDoS attacks. The World Economic Forum ranks cyber attacks among top global risks. Frameworks like NIST Cybersecurity Framework and ISO/IEC 27001 provide structured approaches to managing cyber risks. Key aspects include protecting information systems from unauthorized access, use, disclosure, disruption, modification, or destruction. Cybersecurity is founded on the CIA triad: confidentiality, integrity, and availability. OECD guidelines outline 9 fundamental concepts including awareness, responsibility, and risk assessment. The field's importance has grown with increasing digital interconnectedness, requiring a comprehensive approach addressing technical, organizational, and human factors. Cybersecurity system for critical information infrastructure, subjects, objects, and protection measures. Critical information infrastructure, CII, is essential for national economy, security, and public health. The EU's NIS Directive NU.S. CISA defines CII as systems vital for societal functions. Key sectors include energy, finance, healthcare, transportation, and telecommunications, each requiring tailored protection strategies. Risk assessment is fundamental to CII protection, following methodologies like NIST SP 800-30. Technical measures include network segmentation, firewalls, and intrusion detection systems. Organizational measures complement technical solutions, including comprehensive policies, personnel training, and incident response plans. Effective incident response is crucial, with plans following guidelines like NIST SP 800-61. These elements form a comprehensive approach to protecting critical infrastructure against evolving cyber threats. State policy in cybersecurity, goals, objectives, and priority directions. State cybersecurity policy provides a comprehensive framework for protecting national digital assets and infrastructure. Legal foundations include national legislation, executive orders, and constitutional provisions. The U.S. Cybersecurity Enhancement Act and EU Cybersecurity Act provide legislative bases for national strategies. Goals include protecting critical infrastructure, enhancing cyber defense capabilities, fostering a secure digital economy, and strengthening international cooperation. priority directions often focus on critical infrastructure protection, combating cybercrime, and promoting innovation and research. Implementation mechanisms include national action plans, maturity models, and certification schemes. Funding and resource allocation reflect national priorities, demonstrating the strategic importance of cybersecurity in national defense and economic stability. Legal regulation of cybersecurity at the international level, universal and regional acts. International cybersecurity law includes treaties, customary law, and non-binding norms governing state behavior in cyberspace. The Tallinn Manual 2.0 analyzes how international law applies to cyber operations. UN Resolution 7237 emphasizes the UN Charter's role in guiding ICT use. The Budapest Convention provides a comprehensive framework for addressing cybercrime. Regional frameworks include the EU's NIS Directive and Cybersecurity Act. The African Union Convention addresses cybersecurity and data protection. These diverse approaches reflect the complex task of regulating cybersecurity across different legal systems and technological capabilities. International cooperation remains crucial for addressing the global nature of cyber threats, despite challenges in harmonizing diverse national interests. The role of platforms in ensuring cybersecurity, responsibilities, obligations, and mechanisms of interaction with the state. Digital platforms play a crucial role in cybersecurity, acting as both potential threat vectors and defenders. The legal framework for platform cybersecurity includes the EU's NIS Directive and the US CISA. Platform obligations include implementing security measures, incident reporting, and conducting risk assessments. Platforms face unique challenges in managing user-generated content and third-party applications. Cooperation mechanisms between platforms and governments are critical, including information sharing initiatives and participation in cybersecurity exercises. Emerging technologies present opportunities and challenges, requiring platforms to continuously adapt their security strategies. These issues highlight the complex role platforms play in the cybersecurity ecosystem, necessitating careful navigation of legal, ethical, and technical considerations. The role of the private sector in ensuring cybersecurity, public-private partnership models. The private sector plays a crucial role in cybersecurity, owning over 85% of critical infrastructure. Public-private partnerships, PPPs, leverage private expertise with government capabilities. The NIST framework provides a common language for collaboration. Legal frameworks like the U.S. CISA 2015 facilitate information sharing and collaboration. PPP models include Information Sharing and Analysis Centers, ISACs, and the Cyber Information Sharing and Collaboration Program, CISCP. Joint cybersecurity exercises enhance preparedness and collaboration. The private sector contributes significantly to cybersecurity innovation and R&D. These partnerships are essential for addressing the complex and evolving landscape of cyber threats, combining the strengths of both sectors to enhance overall national cybersecurity posture. Standards and best practices in cybersecurity, international and national experience. Cybersecurity standards and best practices provide systematic methods to safeguard information systems and data. Key frameworks include the ISO/IEC 27000 series and NIST Special Publication 800-53. Industry-specific standards address unique sectoral challenges, such as PCI DSS for payment card security. National cybersecurity standards reflect country-specific priorities, like the UK's Cyber Essentials scheme. Identity and access management best practices are critical, with standards like NIST SP 800-63 providing digital identity guidelines. Network security best practices protect networked systems and data. Data protection and encryption practices safeguard sensitive information. These standards and practices collectively aim to create a robust, globally recognized framework for cybersecurity management. Organizational and legal foundations of cyber incident response, plans, protocols, and response centers. Cyber incident response is crucial in modern cybersecurity strategies. NIST SP 800-61R2 defines its components. Legal frameworks, like the EU's NIS Directive, mandate incident reporting for essential services. Incident response planning is crucial, with key components including team structures, roles, and communication protocols. Computer Security Incident Response Teams, CERTs, play a critical role in coordinating cybersecurity incident management. Information sharing is essential for effective incident response, facilitated by frameworks like the Traffic Light Protocol. Legal and ethical considerations permeate cyber incident response, including privacy concerns and chain of custody for digital evidence. These elements collectively form a comprehensive approach to managing and mitigating cybersecurity incidents effectively. Cyber hygiene as an element of legal culture in the information society. Cyber hygiene refers to practices maintaining system health and online security. It forms the foundation of cybersecurity compliance, exemplified in regulations like GDPR. Key components include password management, software updates, data backup, and security awareness. The legal framework for cyber hygiene has evolved significantly, with regulations like the US CISA promoting threat information sharing. Social engineering awareness is critical in cyber hygiene, addressing the human element in cybersecurity. Physical security and clean desk policies are crucial aspects often overlooked. Cyber hygiene is fundamental to legal culture in the information society, reflecting shared responsibility for a secure digital ecosystem. Its integration into legal culture is essential for maintaining security and trust in the digital age. Strategic cybersecurity planning and cyber risk prevention at various management levels. Strategic cybersecurity planning aligns security initiatives with business objectives. It involves developing a long-term framework for managing cyber risks. Cyber risk assessment and management are cornerstones of effective strategies, using methodologies like FAIR for quantitative approaches. Cybersecurity metrics and KPIs measure strategy effectiveness. Incident response and business continuity planning are critical for managing breaches. Supply chain and third-party risk management are crucial in interconnected ecosystems. Cybersecurity workforce development addresses skills shortages, with frameworks like NICE providing standardized taxonomies of roles and competencies. These elements collectively form a comprehensive approach to cybersecurity strategy and risk management across various organizational levels. It's neat to say that cybersecurity has become an integral part of our digital society, requiring comprehensive legal frameworks and implementation mechanisms. As we've explored, from critical infrastructure protection to cyber hygiene practices, the field encompasses a wide range of activities and stakeholders. The evolving nature of cyber threats necessitates continuous adaptation of strategies, cooperation between public and private sectors, and the development of robust legal and organizational frameworks. As we move forward, the challenge lies in balancing security needs with innovation, privacy, and fundamental rights in an increasingly interconnected digital world. Human rights in the digital age. The digital age has transformed the landscape of human rights, presenting new challenges and opportunities for their protection and realization. This section explores the intersection of human rights with digital technologies, examining emerging issues and legal responses in various domains. Protection of human rights in the digital age, new challenges and approaches. The digital age presents unprecedented challenges to human rights protection. UN Human Rights Council Resolution 3213 affirms that offline rights must be protected online. New rights like internet access and the right to be forgotten are emerging. Digital technologies raise complex questions about jurisdiction, enforcement, and non-state actors' roles. The power of tech companies in shaping public discourse demands a re-evaluation of state-centric human rights models. Human rights affected by digitalization include civil and political rights, e.g., freedom of expression, privacy, economic, social, and cultural rights, e.g., education, work, and solidarity rights, e.g., development, healthy environment. This evolving landscape necessitates adapting traditional human rights frameworks to address the unique challenges of the digital realm. Legal regulation of social networks, balancing rights and responsibilities of users and platforms. Social networks have reshaped modern communication, necessitating careful legal regulation to balance user rights and platform responsibilities. Key challenges include content moderation, data protection, competition, and user rights. The U.S. Communications Decency Act Section 230 provides broad immunity for user-generated content, while the EU's Digital Services Act adopts a more nuanced approach. Content moderation on social media platforms challenges the balance between free expression and combating harmful content. Germany's Network Enforcement Act mandates rapid removal of illegal content, while the EU's Code of Conduct on countering illegal hate speech online represents a collaborative approach. These diverse approaches highlight the challenge of balancing free speech with other societal interests in the digital age. Freedom of expression and censorship in cyberspace, international standards and national practices. Freedom of expression in cyberspace is a critical human rights issue. Article 19 of the UDHR, Universal Declaration of Human Rights, and ICCPR, International Covenant on Civil and Political Rights provide foundational principles, but their application to cyberspace is complex. The UN Human Rights Council has set standards for online free speech. National approaches to regulating online expression vary widely, from the U.S. First Amendment's robust protection to China's comprehensive internet censorship. Content moderation and platform governance are central to online speech regulation. Legal challenges like Prager University v. Google have generally upheld platforms' right to moderate content. Regulating online hate speech and extremist content requires balancing free expression with protecting vulnerable groups. Disinformation and fake news online have prompted various regulatory responses, reflecting the complex task of maintaining information integrity while preserving free expression. Digitalization of education, e-education models, technologies, and legal aspects. E-education has revolutionized traditional learning, expanding global access to education. It encompasses online, blended, and hybrid learning models, utilizing technologies like learning management systems, LMS, massive open online courses, MOOCs, and adaptive learning platforms. The global e-education market is projected to reach $350 billion by 2025. Data protection in e-education presents legal challenges due to sensitive student information and global reach. In the US, FERPA protects student data, while GDPR impacts EU e-education platforms. Intellectual property in e-education encompasses complex issues at the intersection of copyright, fair use, and digital content distribution. Accessibility and non-discrimination in e-education are critical legal and ethical imperatives, with legislation like Section 508 of the Rehabilitation Act mandating accessibility standards in the U.S. Legal regulation of digital medicine and telemedicine, e-health, medtech models, technologies, and legal aspects. E-health and telemedicine are transforming healthcare delivery using digital technologies. The global e-health market is projected to reach $509.2 billion by 2027. This growth brings legal and ethical challenges in data privacy, medical liability, and cross-border practice. E-health services include teleconsultation, remote monitoring, digital therapeutics, mHealth apps, and AI diagnostics. Data protection in e-health presents legal challenges due to sensitive health information and global service reach. In the US, HIPAA protects health data, while the EU's GDPR has far-reaching implications for e-health services. Medical liability in telemedicine presents unique challenges, with cases like Estate of Fry v. Stony Brook Suites emphasizing comparable standards of care for telemedicine. Licensing and credentialing in telemedicine pose regulatory challenges, especially for cross-border healthcare. Digitalization of labor relations, e-labor, new forms of employment and protection of workers' rights. E-labor has transformed work, introducing flexibility and challenges to traditional employment. It encompasses remote work, gig economy, crowdsourcing, and AI-driven management. The EU's directive on transparent and predictable working conditions addresses these challenges. Remote work has gained prominence, with legal disputes often focusing on overtime claims and work-personal time boundaries. The gig economy challenges traditional employment notions, with worker classification remaining central, as seen in cases like Uber BV v. Oslam. AI integration in employment presents legal challenges and opportunities, with the EU's AI Act addressing algorithmic management. Digital surveillance and employee privacy are critical in e-labor, with GDPR providing a comprehensive framework for employee data protection in the EU. Ecology and sustainable development in the digital age, e-ecology, e-sustainability, legal aspects and technological solutions. E-ecology and e-sustainability represent a paradigm shift in addressing global environmental challenges through digital technologies. The UN recognizes digital technologies' potential in achieving sustainable development goals. The European Green Deal exemplifies efforts to harness digital innovation for sustainability. International environmental law is adapting to the digital age, with the Paris Agreement's transparency provisions leading to digital platforms for monitoring emissions commitments. E-waste management and circular economy initiatives are focal points of environmental legislation, with the EU's WEE directive setting ambitious e-waste targets. Energy efficiency and smart grid technologies are key focuses of environmental legislation in the digital sector, with the EU's Energy Efficiency Directive addressing data center efficiency. Esports, concept, ecosystem, and legal regulation. Esports has evolved into a global phenomenon of professional competitive video gaming. The industry has experienced rapid growth, with projected global revenues of $1.8 billion in 2022. However, it faces legal challenges in intellectual property, player contracts, gambling regulations, and tournament organization. Intellectual property in esports is complex due to its digital nature and multiple stakeholders. Copyright issues relate to game ownership, as seen in cases like MDY Industries v. Blizzard Entertainment. Esports player contracts and labor rights are evolving rapidly, with debates over player classification as employees or contractors. Esports gambling and betting present significant legal challenges, with regulatory bodies like the UK Gambling Commission taking proactive stances. Digital diplomacy, digital culture, and digital heritage, legal aspects of development and preservation. Digital technologies have transformed diplomacy, culture, and heritage preservation. The UNESCO Charter on Digital Heritage Preservation, 2003, recognizes the need to safeguard digital cultural legacy. Legal challenges include jurisdiction in cyberspace, intellectual property rights, and frameworks for digital heritage preservation. The legal framework for digital diplomacy is adapting to address challenges in conducting international relations digitally. Digital culture presents complex intellectual property challenges, with debates over AI-generated work sparking questions about authorship and originality. Digital heritage preservation intersects with copyright, data protection, and archival legislation, with UNESCO's 2015 recommendation providing a framework for addressing these challenges. The future of CyberLaw, forecasts and development scenarios in the context of digital society. The future of CyberLaw intersects rapid technological advancement with evolving societal needs. Key areas include AI governance, quantum computing implications, and space cyber convergence. Central issues involve addressing jurisdictional problems in a borderless digital world, developing regulations for new technologies, and balancing innovation with human rights protection. AI governance is a critical frontier in cyberlaw evolution, with the EU's AI Act aiming to set global standards for AI regulation. Quantum computing challenges cybersecurity law, requiring re-evaluation of cryptographic standards and data protection frameworks. Space law and cyber law convergence is driven by increasing reliance on space-based technologies, necessitating new regulations for cybersecurity in space systems and governance of satellite internet constellations. The digital age has profoundly transformed the landscape of human rights, introducing new challenges and opportunities across various domains. From the regulation of social media to the protection of digital labor rights, the intersection of technology and human rights requires innovative legal approaches and continuous adaptation. As we move forward, the key challenge lies in harnessing the potential of digital technologies to enhance human rights while mitigating associated risks and ensuring that fundamental rights are protected and promoted in the digital realm. Conclusion. Our exploration of Introduction to Cyber Law, from general law to the digital era, has taken us on a comprehensive journey through the evolving landscape of legal frameworks in the digital age. We've witnessed how traditional legal concepts have been adapted, challenged, and transformed to address the unique characteristics of cyberspace. We began by examining the fundamental principles of cyber law, tracing its origins from general law to its emergence as a distinct field in response to the digital revolution. The rapid evolution of technology has necessitated equally swift adaptations in legal thinking, from the regulation of e-commerce to the protection of digital rights. As we progressed, we delved into the complexities of digital sovereignty, e-governance, and the economic implications of cyber law. We saw how these new legal frameworks are reshaping government operations, business practices, and economic structures in the digital era. Our journey then took us through the intricate web of information infrastructure, personal data protection, and the ever-present challenge of cybercrime. These areas highlight the delicate balance between innovation and security, privacy and accessibility. The transformation of legal advocacy and judicial systems in the digital age demonstrated how technology is not just changing the subjects of law, but the very practice of law itself. E-judiciary and online dispute resolution are redefining access to justice and the efficiency of legal processes. We explored the critical domain of cybersecurity, underscoring its importance in protecting our increasingly digital lives and the legal mechanisms being developed to ensure this protection. Finally, our examination of human rights in the digital age brought us full circle, reminding us that at the heart of all these technological and legal developments are fundamental human values and rights that must be protected and promoted in this new digital landscape. As we conclude, it's clear that cyber law is not merely an extension of general law into the digital realm, but a dynamic, interdisciplinary field that continues to evolve rapidly. It requires ongoing adaptation, international cooperation, and a delicate balancing act between fostering innovation and protecting individual rights. The journey from general law to cyber law reflects our society's broader transition into the digital era. As technology continues to advance, the legal frameworks governing our digital interactions will undoubtedly continue to evolve. The challenge for legal professionals, policymakers, and citizens alike is to stay informed, engaged, and adaptable in this ever-changing digital legal landscape. This introduction to cyber law serves as a foundation for understanding the complex interplay between law and technology in the 21st century. It invites further exploration and continual learning as we navigate the exciting and challenging frontiers of the digital era. Thank you for the attention.